By this time, we were both half crazy from too much whiskey, sun fatigue, culture shock, lack of sleep, and general dissolution. We hung around the press box long enough to watch a mass interview with the winning owner, a dapper little man named Layman, who had just said he had flown into Louisville that morning from Nepal, where he'd bagged a record tiger. The sports writers murmured their admiration, and a waiter filled Layman's glass with Chivas Regal. He had just won $127 grand with a horse that cost him $6,500 2 years ago. His occupation, he said, was retired contractor. And then he added, with a big grin, I just retired. Well, that means that this is IJ's annual preview of the Kentucky Derby. Those words were from Hunter S. Thompson's famous essay of the 1970 Derby. And so we want to give to you perhaps the chance to retire. And that's with the odds that will be given by IJ's own Kentucky boy, Brian Morris. We'll hear from him, and then we'll hear from him about some actual legal issues, that being a case from the Sixth Circuit, the Kentucky Derby's own circuit, involving easements and a pipeline. Then we'll move on down to Florida and hear from Evan Lisull, who is IJ's own legal writing guru. Evan will give us some legal writing tips and then discuss a First Amendment case from Florida in the 11th Circuit, which will have some very Florida facts. And although we won't get terribly into them, it may be a time to hit pause if you have some younger listeners. That's because some of the plaintiffs in this First Amendment case from Florida have plaintiffs such as Wacko's 2, MHHS Sensations, Pat Milt Inc. DBA Passions, Bear Assets Inc., which apparently doesn't need a DBA, and SES Jacks Inc. DBA Flash Dancers. All that and more this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Monday, April 28th, 2025. The episode, we believe, will come out as normal on Friday, May 2nd, 2025, and then the Derby is run late in the afternoon on Saturday, May 3rd this year. So if you're listening to this in the first 24 hours the episode is out, you are in luck, because you are going to hear the knowledge you need to retire at the Kentucky Derby with the usual disclaimers applying. So we're going to hear from Brian in a moment on that, and then we're also going to hear from Evan at the end of the show of a little bit about that Hunter S. Thompson essay and legal writing tips along the way. So let's move now to Brian Morris. So Brian is, as I said, a Kentucky boy. For those of you who haven't listened to every episode of the show the last 4 years or so, you would not perhaps know that Brian has come on year after year just before the Derby to give his thoughts. I think one year it was too late, so we did the Belmont instead. But this year we're in time for the Derby. We got the horses running. We got some cool names as always, including some that have a legal spin on them. So Brian, what are you watching this year?
You know, it's I'm glad to be here for gambling and strip clubs today. So, you know, I remember last year.
Didn't design it that way, guys. It just kind of came together.
You know, last year was one of the most exciting derbies I've ever seen, which I don't know if you remember. It was a three-way photo finish, which I think, if I remember correctly, and if I didn't say this on the podcast, I'm remembering that I said it. I think we actually picked Mystic Dan on the podcast. So those were 18-1 odds. So here's your chance. You know, so the Kentucky Derby, you know, it's the fastest 2 minutes in sports, which you know, I still think there's only two horses to ever go under 2 minutes, which, you know, Secretariat from, you know, 75 still holds the record. Which I was just watching, I saw a tweet the other day. I don't know if Anthony, if you've seen Secretariat win the video of when he won the Triple Crown in the Belmont Stakes.
I must have at some point.
So he won by 30 lengths.
Oh, yeah, I remember that, yeah.
Which there were some tweets recently to put that in perspective. You know, the Masters just concluded. That would be the equivalent of someone winning the Masters by 15 strokes, or someone winning the Super Bowl by 96 points.
Yeah.
So it's but this year the odds-on favorite is a horse called Journalism at 3-1, which won the Santa Anita Derby, which is a big lead up to the Derby. And horse racing is all about pedigree, which Anthony, your royal backgrounds could appreciate. So
yeah, if you go back about 500 years, it's in there.
So Journalism's dad is a horse called Curlin, who won the Preakness back in 2007. So it's like won 4 races in a row. This is where most of the horse racing money is made. The stud fee for Curlin, I think I looked it up, currently is at $225,000. So this horse is a lot of pedigree. But the biggest plot twist probably this year for the Derby is Bob Baffert is back. It's horse racing's favorite villain. He's also wildly successful. He's coming off his ban because his horse tested positive for banned substances after it won. So
we did the case about him, it was like out in the Ninth Circuit. Did you do that case, Brian? That was like 2 or 3 years ago.
I can't remember, but yeah, there's been a ton of litigation following Baffert's horses about who wins when a horse is scratched for testing positive for substances. So, but he's back with 2 horses this year: Citizen Bull at 20-1 and Rodriguez at 12-1. But the Citizen's Bull, I think, was doing really well. It's probably I would imagine those odds are gonna come down a little bit. But you can always, betting on Baffert at the Derby is always a safer bet. But then my 2 favorites probably, there's a horse, Dovetail is another case I'll be talking about, but called Sovereignty, which is a good IJ name as well. But it's, if we're talking about pedigree, it's great grandpa, so double great, is affirmed in Seattle Slew, both who won the Triple Crown. And it's a Kentucky horse, so you got to root for the hometown favorite, which, Anthony, after the podcast is over, maybe we can have lessons on how to say Louisville correctly.
Probably needs a bourbon or 2, right?
You got to swallow it a little more.
Yeah.
Louisville.
Yeah. You have to have a few drinks in, and then it'll come out.
Exactly.
That's true. I tend to not do that right before a podcast, but next time we speak.
And then if you want a long shot, I always, the way I like to bet, which never wins, is, doing a try box with a long shot, because that's the real payout. So there's a horse called Owen Almighty, which is 30-1, which is the longest in the race this week, which is a little surprising. There's not, sometimes you'll see a 40-1 or a 50-1, but 30-1's the longest odds. But it won the Tampa Bay Derby. It beat a horse that I really liked in that Derby that didn't make this Derby. So that's Owen Almighty. You heard it here first. It's all the money on. But it drew the 20 post, which is way on the outside. One of the fun things about the Derby, for listeners if they're not familiar, a lot of horse races might have 7 or 8 horses in it. The Derby has 20. So it drew the post way on the outside. So if it makes a fast break, I think it could be up there. So.
Okay. It's cool you raised Secretariat and winning by 30 lengths. I was reading not long ago some sports science thing, and it said, talking about the distribution that you have in all sports about talent and all that. And basically, there's 2 examples of absolutely breaking the curve, and one is Secretariat, and the other is Missy Franklin, the swimmer.
Yep.
And both of them are just beyond anything you would ever expect in an athlete.
Secretariat still
no way to beat that.
Oh yeah, Secretariat still holds the record for all 3 Triple Crown races. It's the fastest horse for all 3 races.
Well, hopefully some of you can retire on. Although we do not endorse sacrificing everything for betting on the horses, like my grandfather apparently did with the firm's Christmas money one year. It's an old family secret we're not proud of, but. I will instead, we'll move away from gambling. Evan later is going to talk about this First Amendment case, but he's also, he corrects all of our writing at IJ, and he does a fantastic job at it. He's going to have a few tips, but just give us a quick preview on what you'll be sharing with us, Evan.
Yeah, so I want to kind of shift a little bit to something even more boring somehow than appellate writing tips and talk about kind of the wide world of citation. So a lot of what I do is cite checking at IJ, and that means making sure that when we cite a legal principle, it actually stands for that principle, and also making sure that it looks right, that we use the right format. And a lot of lawyers out there are thinking the legal blue book, and they're cringing, and they're kind of having these Pavlovian shocks from 2L, maybe 3L year, being subjected to its many rules and intricacies. And there's certainly a lot of that. But what I think a lot of lawyers maybe don't realize is that there's a whole world beyond the blue book, and a lot of courts don't use it and recommend against using it. And I want to tie this in to our argument tomorrow in Martin v. United States, where IJ will be arguing before the Supreme Court on a very important issue involving the Federal Tort Claims Act. This is not going to be about those legal issues. This is going to be about how those briefs look and why they look the way that they look.
Ooh, that sounds juicy. And of course, by the time listeners hear this, we'll know all about the Martin argument, and we'll talk about on later shows too, I'm sure, and have Patrick Giacomo, who is doing the arguments, back on Short Circuit. But until that time, we're going to go north of Lowerville, if you want to say it, way up to almost to the UP in northern Michigan, where, as people know, Michigan's divided into two halves, and there's a pipeline under the water there that apparently is not very popular these days. So Brian, what's that about?
Yeah, so this case came out of the Sixth Circuit last week. It's called Enbridge Energy versus Whitmer, so the Michigan governor, and it's a pipeline that runs from Wisconsin through Michigan and then into Canada, and Enbridge has this easement to run the pipe between, as you were explaining, the upper and lower peninsulas, which crosses the bottom of, I guess, speaking of pronouncing things correctly, it's Mackinac, right?
It is Mackinac, correct.
Okay. The Mackinac Straits. So the state owns the submerged land at the bottom. And Enbridge has had this easement since the 1950s. And a few years ago, Governor Whitmer tried to revoke the easement. And I think the claim is, the state's worried about ruptures or, a ship's anchor hitting the pipeline or something having a spill. But in response, Enbridge filed this federal lawsuit seeking an injunction to essentially stop her and the state from interfering with the easement, and has different, I think there's three arguments. There's a supremacy clause argument, an interstate commerce argument, and then I think a federal commerce clause argument as well. None of the merits are at issue in this appeal, but it's whether or not they can, as IJ knows in a lot of their cases when you sue the government, it takes years to even get to the merits of the case. So this litigation is years in the making, just about whether or not 11th Amendment immunity applies. And 11th Amendment immunity, as a reminder, bars you from suing a state in federal court. So for 100 years, though, you've had one of the biggest exceptions out there, which everyone knows as Ex parte Young, which is a legal fiction that just says, you can sue the individual state officials in their official capacity, not the state itself in federal court. So if I remember correctly, it's the Ex parte Young was an old railroad case. I think when there was, Minnesota passed a law enjoining railroads from charging a certain amount of money, and then the AG was sued seeking an injunction to prevent the enforcement.
Yeah, you're testing my knowledge,
Yeah.
and I should know this because I live in Minnesota, but I didn't even remember that it was a Minnesota case.
For a case that shows up like every day, I
Every
couldn't
day.
tell you the first.
But it's because they sued.
What happened? Who's young? Like,
But they sued, someone. They sued the AG basically not to enforce this state law, and they said, well, they named him in their individual capacity, so that was okay,
Right.
in their official capacity as an individual officer.
It's slicing things pretty thin, but it does make sense that this fella enforces the law. You're just suing the fella. You're not suing the state. And so the relief will be that this person who's in charge of enforcing the law can't do it.
Yeah.
So you don't have to say you're actually suing the state. And you can't, of course, you can't sue for damages. This is only about getting an injunction or a declaration.
Correct. Yeah. So the kind of the boxes you have to check is that you actually are suing a named official, not the state itself. There is an ongoing violation of federal law, and as you were just mentioning, there's prospective relief only. So it's like an injunction to stop the violation, for example. But in contrast, if you're actually suing the state, the 11th Amendment immunity applies, which this one I do remember. I looked it up, but that goes back to the old Chisholm versus Georgia case, which was a Charleston merchant was owed a bunch of money that Georgia took supplies to help when the Continental Army was in a state. The merchant wasn't paid, so he sued, I think it was actually the estate, but sued the state of Georgia, and the Supreme Court said that was fine. And so that actually provoked the passage of the 11th Amendment.
And then the 11th Amendment's actual terminology only applies to citizens from outside of state suing the state. But then it's read to actually, it's not really 11th Amendment, it's just reaffirming sovereign immunity and overturning Chisholm versus Georgia, which I contend was correctly decided, but we don't need to have that fight right now.
So here, Enbridge says Governor Whitmer, they say, hey, look, this is straightforward. Look, we sued Governor Whitmer in her official capacity. She's allegedly violating the Constitution. And we just want forward-looking relief that says, hey, you can't mess with our easement. And so it would seem like a straightforward application under Ex parte Young. But the tricky part is the Supreme Court said even if a plaintiff checks these boxes and everything looks correct, you still have to look at the effect of the relief to see whether the plaintiff is really trying to do an end run around sovereign immunity, and what they're really trying to do is sue the state. So there's this case from the 90s. It's Idaho versus Coeur d'Alene, and the
good pronunciation, by the way.
Yeah, A+.
Thank you.
Our Idaho listeners will be proud of you.
So the Coeur d'Alene tribe sued state officials because I think it was just part of a lake. They claimed ownership to part of a lake, and they sued. They checked all the right boxes, but what they actually wanted was they wanted ownership of the lake. They wanted what would be essentially a quiet title action to say, hey, we get ownership of the lake and completely exclude the state from regulating or doing anything on that part of the lake. So typically, or not typically, the tribe would have been barred by the 11th Amendment from bringing a quiet title action directly against the state. So, the Supreme Court said that even though they checked all the right boxes, still barred. Ex parte Young does not apply because they're really trying to get this quiet title from the state. So this oral argument I listened to was really interesting because it's kind of all about, does Coeur d'Alene apply? And kind of the whole thing was, well, what is this easement? If the pipeline company has this easement and this injunction against Governor Whitmer, does the state of Michigan still have any rights left, or are they effectively saying we get this property? And it's interesting. I don't know. We'll see if this shows up for the listeners. They argued over this pipeline over and over again, but you can see it's like this submerged pipe that just is a couple inches above the bottom of the water, and it just kind of goes across the strait.
So for our on YouTube audience has just seen that picture, but for listeners, if you want to see it, go to YouTube. But yeah, it's a picture of a pipe. It's actually not as big as I would think.
I looked it up.
Pipes
like
in our septic
sewage from your house. Yeah,
correct. It's a pretty. During the oral argument, the lawyer for Enbridge was like, "This is just a small little pipe that goes across the bottom," and I was like, kind of rolling my eyes, and I looked it up. It goes, "That is just a small little pipe that goes across the bottom of the strait."
But with like zillions and zillions of gallons of whatever it is,
nonstop oil, right?
Yeah,
correct. So the state's saying, look, what Enbridge wants is they want to own this property. Like they're basically wanting to restrict Governor Whitmer in the Michigan from regulating this, doing anything as it relates to the pipeline. And the companies say, no, we just want to run our pipeline. You can't violate the Constitution in doing that, but otherwise you can tell us whatever you want. So I think one of the interesting things about this case, and it shows up in the opinion, is that the opinion actually cites specifically to the oral argument transcript twice, which you don't see a whole lot. And I think it shows the importance of oral argument, because the judges were really, I think, trying to work through with both advocates kind of, well, what would the state of Michigan, what interests would they still have? And Judge Kethledge is on the panel. He's actually from Michigan, notoriously has a cabin up in Michigan that he writes his opinions in. I mean, is a brilliant guy. And I think to some of his chagrin, the advocate for for Enbridge is a DC lawyer who I don't think was quite up to task on answering all of his questions about the geography, about, Judge Kethledge kind of laughed that he didn't know where the pipeline was in relation to the bridge, and things like that. But they went through this great hypothetical about, well, what could Michigan do? And one of Judge Kethledge's was, well, there's these zebra mussels that are very invasive, and if they're all over the pipe, could the states, require the company to clean them up or do different things? And the answer was yes. He's like, yeah, of course. There's nothing in the injunction that would prevent the state from doing this. And Judge Moore had a hypothetical about, if they wanted to put in a commuter rail that went underneath the floor of the strait, could they do that? And he's like, yes. So I think the judge has really worked through some hypotheticals and showed the importance of the oral argument. And then they ultimately came out and agreed with the pipeline company and said, this pipeline is just for the pipeline. They could still put other utilities lines across. They could still do other things. They can still regulate it. So it falls into the bucket of ex parte Young and not Coeur d'Alene. One of the things that you remember from property rights class in law school is you talk about the bundle of sticks, for example. And here it was just, maybe the pipeline company gets to have one of the sticks, but the state keeps all of the rest of the sticks. So in that situation, you can bring an action under ex parte Young. You can sue Governor Whitmer, and from my perspective, I think it's a win. It's the right opinion. That then I think it's always good when courts don't find these jurisdictional reasons to let the government off the hook of accountability.
So Evan, I learned in property class about easements, which I always thought were fascinating, and that it's only part of the bundle of sticks. It seems to me here the court has kind of like a part of the bundle rule, and it seems to have really no basis in any actual rule of law. That Coeur d'Alene is a weird case, and somehow we need to keep ex parte Young.
I mean, right, it's a sorties problem, right? Like, how many sticks does it take until you've lost sovereignty? I don't know, and I don't know if they have an answer, right? I mean, that's a philosophical problem. But I think the Coeur d'Alene case is just, I don't know, it's kind of weird, and I can see the concern. But, fundamentally in the background here, and Brian, I think you were working on this case. What would stop Michigan here from just exercising eminent domain over the easement? Is there, and then they would seek just compensation, but as we know, they might just give them a bunch of IOUs in response. Is that, I mean, not to give them ideas, hopefully the state of Michigan isn't listening to this podcast, but would that be an option for the state here, or?
Yeah, I mean, it'd be interesting. I suppose their argument could be that the public use is protecting the environment or something.
Right. I mean, they don't really need one, right? It's a public thoroughfare or something. They're public waters, right? And just say, all right, well, we've tried to regulate you. You say we can't regulate you, so we're just going to take it, and you're going to ask for just compensation, and we're going to drag that out for years.
Just compensation for all that oil. Probably
right. I mean, that's what they would ask for, certainly, right? They would say, we would have had X gajillion barrels go through here, and you've deprived us of that. And they say, okay, here's Whitmer bucks. You can spend them anywhere in the Upper Peninsula. It's good. It's a good just compensation. And so I could just see how the state, if they wanted to get really Machiavellian about it, would, say, okay, we can't regulate you. We'll take you then. And in the meantime, right, they don't have the oil or gas or whatever it is, right? They wouldn't have that. And so I don't know. I mean, it'd be interesting to see how this plays out down the road, as a practical matter. But yeah, I think it's good. I think Brian's right. Fundamentally, as a matter of law, like this is just a classic kind of suit that should be heard. And let Michigan argue that they've breached the terms or whatever. Say that they're not complying with federal law. But let's get to the merits rather than just getting out on an 11th Amendment, get out of court free card.
Yeah,
which is so often how it plays out.
Yeah, because there's still a ton of issues. There's
right.
some abstention issues, there's merits issues, there's all these remedy issues. But here, it's the state's just saying, you don't. The courthouse doors are shut before you
exactly.
Get in. Yeah.
Yeah, they say that on remand now there's going to be younger abstention is
right.
another thing they're going to have to deal with. Our old friend, which seems like an odd place to have younger abstention.
Yeah, I didn't really understand that. I mean, I didn't dive as deep as Brian, but that footnote kind of, I've furrowed my eyebrows at that.
One thing so this is kind of a legal writing point that I did not like about the opinion is they talk, because there's this other litigation going on, brought by the Attorney General. And so they say the Attorney General, I think when she first got in office, Dana Nessel, and who I think is still the AG there. And then they refer to her later as General Nessel, which I know the Supreme Court does this for the Solicitor General, but Attorneys General and Solicitors General, they are not generals. They don't have like 4 stars across their shirt. Does this bother you guys too?
Yeah, I think it's weird personally. I can't tell you if you really want to do it that it's not right or anything, but to me it sounds wrong. Again, it's the military connotation that's too overpowering.
Brian, does it ruffle your feathers?
No, I completely agree. I mean, I understand like kind of the, some of the pomp and circumstance of having an argument in SCOTUS, that, they use the term general to address people. But yeah, I mean, I don't. I'm more probably laid back and just think that you should just reference people as AG in the opinion, but
Yeah.
Yeah, you could say AG Nessel and have the fewer characters and same amount of words. Not that we count here ever.
Well, for some briefs maybe it would work a little better to just have AG.
Nessel, save you the word.
Well, I think that's a good segue then into legal writing. So, Evan, you said you're going to have some highfalutin details about when you get to the Supreme Court. Maybe that blue book you learned about when you're a 1L in law school and you would roll your eyes about it. You get there and you learn maybe they roll their eyes about it too.
That's right. And I think, I think the main thing is maybe for, a lot of this for appellate Twitter folks and whatever is going to be very obvious and kind of boring. They can fast forward to their real interest, which is the exotic
we
dancing.
have like real people who listen to the podcast too, so you can speak to them.
There are dozens of us, right? So for people who aren't familiar, though, you might look at a Supreme Court brief and right away you'll notice that it looks a little different. And part of it's the spacing, part of it's the formatting. But I think if there's one thing that a writer might notice that others might not, is there's a lot of asterisks. There's a lot of asterisks. You kind of say, well, why use the asterisk? And a lot of that derives from the Supreme Court itself, but it's also from the Office of the Solicitor General. Another good transition. The Solicitor General puts out a style guide that I believe they use universally, but is primarily known for its Supreme Court briefs. And this is a rule-by-rule kind of amendment. So an amendment so big that it kind of swallows the whole of the blue book, where they go through rule by rule and say, we'll follow this. We won't follow that. We will follow this. Here we do things differently. Those asterisks you see are actually ellipses. And there's a reason they use the asterisks instead of the ellipses. When you come to the end of a sentence, it's sometimes hard to tell, or if you have a sentence in between, which one's the period and which one's the ellipsis and how it relates. The reason they like using 3 asterisks, which is a hard word to say repeatedly on a podcast, is because it makes it clear what's been omitted and what's an actual sentence-ending period. And so there's actually an argument there. And I thought it was just, this is just highfalutin, this is just pretentious. But there's actually a kind of semantic argument for it that I didn't appreciate until I really started to get into this work. I said, okay,
so if you have a period the end of the sentence, but then you're leaving off the next sentence or part of the next sentence.
Yeah, so if you omit...
You do have a period.
You do have a period, and so that's
Okay.
the period you can make clear is different from the 3 asterisks, whereas before you say, well, is this first part, let's say we have like kind of 2 groups of words, am I omitting from the end of the first group of words or from the beginning of the second? And it's sometimes hard when you have 4 periods in a row to say, well, which one isn't? You kind of have to squint. But if you have the asterisk, it's very clear that it's only the 3 asterisks that are omitted. The period just indicates the end of a sentence.
And so if you omit, say, half of the next sentence, but the second half is in there, or you just omit an entire sentence and then you go to the beginning of a further sentence,
you would
are
have
those
to
asterisks different?
No, you'd have to choose which side. It's going to be the same whether you're omitting. It just you can take out multiple sentences if need be.
But is it just still 3 asterisks?
Yes, it's still 3. You would never have 4 or
Okay.
2 or something strange like that. No, it's always 3, just like the ellipsis. But by using a different character, it makes it more obvious how it is. So there's little things like that. There's things that are even more esoteric. So there's this reporter called the Federal Appendix, which is this is a whole nother episode, but this weird distinction between reported and unreported cases. And so this is a reporter of unreported cases.
Right.
Rest in peace.
I still don't get it. I've been doing this for how many years? Which is it? Right? It's reported, but they're unreported, but they're in a bound volume. Be that as it may.
They're not precedential, right?
They're not. Right. And so that's, we said this thing, we publish it, we put it in a book, but don't rely on it. Don't you dare rely on it. And it's kind of like, well, what is this then? It's odd when you get kind of deep into the weeds about authority and publication and things like that. And so the Blue Book now says you should do F period APP apostrophe X. And that's how you kind of do it for the Blue Book and most Blue Book. But for the Solicitor General, it's FED period APPX period. And the reason is because Michael Dreeben said so in 2003. And it's literally, if you look up the Office of the Solicitor General Guide, it says, per Michael Dreeben, we will continue to use FEDAPOX. And I kind of lost it when I found that one. I said, he was a qualified Solicitor General. I'm not disputing that, but it's 2025. Why?
And does the Supreme Court in its opinions follow the SG's guide to some extent, or is it just a whole nother thing?
The Supreme Court has its own style guide that overlaps but is not perfect and is not actually recommended for practitioners. It's just their kind of own internal publication manual that the U.S. reporter will follow. And so then it's kind of like, well, who are we appealing to? Why are we doing it this way? And a lot of it's just kind of fitting in, right? You want your briefs to look like the best, and the Office of the Solicitor General, whatever you may feel about the positions they take, put together a very professional brief. It always looks the part. And so I think part of that is looking the part, going before the court, dress your best. They're the ones who have said it's the 10th Justice, the Solicitor General. And I think, as much as you can emulate that aspect of the practice, that's the best practice for your own firm, is to try to look the part. Since the Solicitor General Guide is out there, if you ever find yourself just submitting a Supreme Court brief, different people have different opinions, and it's not like a guarantee or anything, but it's just a little something you can do to nudge your foot a little more in that very small and often closed door.
Right. And it's the same rules for a cert petition?
Yes, cert petition and merits briefs are all following the same style.
Right. And they have these little booklets instead of a full-size
that's right.
piece of paper.
Luckily that I don't have. That's our incredible undefeated paralegal team here. Best in the business, no question. They make sure that magic happens. So it looks very nice when it's done, but I don't do the printing side.
Well, wonderful. Well, another place where the magic happens is a certain establishments in Jacksonville, Florida. But there was a little too much magic for the city councilors there, so they passed this ordinance, and they're saying it restricts the First Amendment rights of what they do at these establishments. And so, Evan, what did the 11th Circuit think about that?
That's right. So I think it's important before getting into this to start, I think a lot of people, a layman's view might be, well, what was the First Amendment even involved here? It's pretty undisputed that the First Amendment protects exotic dancing writ large. It sounds strange, and it may be, it goes against your priors, but, you think about there's a lot of expressive speech that's been protected. You can think of the black armbands. You can think of silent demonstrations. There's a lot of speech that isn't written words or spoken
Chalking
words.
on sidewalks?
Chalking on sidewalks, that's right.
A
Not
couple years ago.
delve into criminal past, or not criminal past, actually. But things like that, that's exactly right. And so you accept that prior. The other thing that's kind of important here is a case that we cite a lot in our First Amendment work, which is Reed versus Town of Gilbert, which was a signage case. But it kind of has this important overarching rule that I'm going to read before getting into the First Amendment case. It's a brief little excerpt. A speech regulation targeted at specific subject matter is content-based, even if it does not discriminate among viewpoints within that subject matter. And so there he uses the law that bans sound trucks for political speech, and only political speech would be content-based, even if it imposed no limits on the political viewpoints that could be expressed. So you can't just ban a form of speech. That's exactly what happens in Jacksonville. There's two aspects of the opinion, but the one that's kind of more interesting to discuss involves a straight-up ban, no exceptions, no anything, on exotic dancers ages 18 to 21. And so you would think, if you only knew Reed and you had no other background, to say, well, okay, that's a content-based restriction. It only applies to a certain group, no others. Strict scrutiny would apply. But that's not what happens. And so there's two reasons that the court gives for that. We'll start with the court, and then we'll move into Judge Newsom's concurrence. The first
The court is also Judge Newsom. I should.
That is true. So this is Newsom's panel. And Newsom he agrees with the decision. So he's not dissenting here. He's concurring,
which is not that unusual these days.
No. It's a very the very I would have done it differently. Concurrence is common, or maybe somebody else should do it differently. Look, you gotta get the viewers right. So, and so here the courts relies on an even older Supreme Court case. That's Town of Denton. And let me look up the.
Renton, right?
Renton v. I have it right here. Oh, another great name.
I remember that because that Renton is a suburb of Seattle.
That's right. The suburb of Seattle. The Playtime Theaters. I don't know if you remember
when
Playtime
I was
Theaters
growing up as a kid. That was a big story in the Seattle area.
Oh, really? Okay. I didn't know that aspect of it. And so there, they upheld, it wasn't even a ban in that case. They upheld a locational restriction on where adult theaters even could start. This was movie theaters rather than live performances. They just upheld a ban before any theaters could open, which was kind of curious. And that seemed to be a big fixation in the Supreme Court's decision. But they relied on what they called the secondary effects approach. And the secondary effects approach is, look, we're not concerned about the content of the speech. It's not the fact that you're showing adult movies. It's the fact that there's secondary effects from having movie theaters that show adult movies, whether it's crime or, even littering or things like that associated with these theaters. And they claim to have evidence and reports and all these things showing that had happened in other cities. And so those secondary effects allow you to analyze the restriction merely under intermediate scrutiny. But it's hard to square that with Reed. And Reed, the majority opinion of Reed doesn't discuss Renton, but the concurrence, which was one of these which more of a concurrence, with an air of dissent about it, to say, we've upheld these in other contexts. And the concurrence that Kagan wrote does, in fact, mention Renton and say, we've had no trouble applying intermediate scrutiny in these contexts. And so the 11th Circuit's left with this kind of pickle to say, okay, we understand that Renton said because of the secondary effects, we only have to analyze this restriction under intermediate scrutiny. We understand, and we also have 11th Circuit precedent squarely on point saying that because of Renton, this is totally fine to analyze it under intermediate scrutiny. We understand Reed came out after all this happened, but Reed didn't talk about, these kind of establishments. Reed was about signs telling church parishioners which, turns to make. That's totally different. So we don't see Reed as directly overruling it. Our precedent still applies. If you want to have this overruled, you need to take it upstairs. And so that's kind of where they left it. Now, Newsom writes a concurrence, and that was, to be honest, the reason I wanted to discuss this case, because a Newsom concurrence is usually a good sign. They're always interesting, and his is interesting here too. And so, he kind of makes the point that, yes, I see that the precedent is still here. Yes, the secondary effect seems to be in effect, but when you apply the logic of Reed, however different they are factually. We don't really look at it factually. We need to look at what standard applies, kind of in a vacuum. And here there's no reason that Reed's logic wouldn't apply to this case. And you could say that the secondary effects justify this restriction. And here, kind of my background to, we've had the jokes, but a lot less funny is the concern about human trafficking. And there's a lot of relation with human trafficking and exotic dancing. And that was the justification that the city of Jacksonville here offered for the ban.
Especially with the younger set.
Exactly. And that's why I was focused on 18 to 21. That was their justification. These are laudable policy goals and concerns. But Judge Newsom's point is this is downstream of the standard of review. You can argue that after we've decided what level of review to apply. But once you've determined it's content-based, it's got to be strict scrutiny. And you can win. A lot of times it's said, strict in theory, fatal in practice. But, I guess not recently. It feels recently. But in Holder v. Humanitarian Law Project, the government in a national security terrorism context was subjected to strict scrutiny and won. So it can happen. It's not unfeasible. And this honestly feels like a rather close call and something the government could arguably win on. Now, Newsom offers reasons why it might not win, and one of the issues is under-inclusiveness. So remember, with strict scrutiny, it's got to be tailored and has to include everything that's relevant to the concern you're addressing. And here, one of the points that the, petitioners to be the appellants made here is that you're getting dancers who are 18 to 21, you're banning them, but they're still allowed to work at these establishments. And the evidence that was proffered at some point below, or maybe just generally, is that traffickers don't really care if you're on the stage or not. These are just good venues. And again, this is all for the sake of argument. I don't know the actual facts or statistics or anything like that. But you can have them working as hostesses, opening the door, serving tables, bussing tables, things like that. And it's exactly the same kind of concern, the same kind of funnel for the kind of behavior you want to prevent. And they're allowed to. So your restriction is under-inclusive in that respect. And that would be sufficient to strike it down. But again, all of this is downstream of deciding what level of scrutiny to apply. And I think, frankly, that Judge Newsom's, I don't know what argument he would make, because again, as you pointed out, he concurred. He didn't disagree. So I do wish his had been the majority opinion, although again, I don't know where that leaves you as one of these establishments. I guess that sets it up better for a petition, but just because of the bespoke nature of it, it does seem like a hard cert petition to get granted. And, a little frustrating in that respect, right? Because there's a lot of questions still in the wake of Reed that should be answered. And this seems like a perfect example of that.
Well, and part of what's going on is this other case that they discussed, City of Arlington, from a couple years ago, that we originally talked about on Short Circuit before it got to the Supreme Court, which is a while ago now, about the on-premises sign versus off-premises sign, and the court said, that's okay under Reed, which kind of doesn't make sense from the actual wording of the majority opinion in Reed. Brian, where do you see this this moving as we keep trying to sort out, an actual principle from maybe what the judges don't want to do when it comes to enforcing that principle?
As a background idea, I'll keep this in my back pocket the next time I need an excuse to go to a strip club, I suppose. And just
case research.
It's for First Amendment research. Right. It reminds me of
expensive.
It reminds me of what was the movie that won Best Picture this year? Honora. The writer said he spent a lot of time in strip clubs for research for his screenplay.
Wow, paid off, I guess.
Yes. It's interesting. I mean, even in Newsom's majority opinion, they say it feels content-based, and it is content-based, right? And it doesn't apply to other types of dancers, even, such as jazz dancers or ballet dancers. It's just erotic dancers. Right. And it just kind of brushes, I think the whole line of these cases just kind of brushes that aside because it treats it as content neutral just because of the industry. And it reminds me a lot of kind of our First Amendment cases that we have with traditionally licensed spaces like lawyers and doctors and therapists, where it's, courts kind of get into these industries and they get the yips a little bit, and the doctrine kind of goes out the door, and they say, oh well, it's this industry is different when it comes to the First Amendment, and it really shouldn't be, at least for these threshold questions. And I think to your point, Evan, I agree that Florida could have some really compelling interests in this space on trafficking issues and safety, and that could be all and well, but I think it should be held to the regular strict scrutiny standard, and basically come into court and prove it. And I think that's what the government should have to do when they have these type of restrictions. And like exactly what Newsom said in his concurrence is, the more stronger the interest in these types of cases, the more likely the restriction is to survive, and we should be in that world rather than we're just going to kind of put the blinders on when we face certain industries.
Right.
Yeah, it happens in so many areas of law where you can tell the judges are saying, oh, we can't rule that way, so we're going to go down a different track, even though there's not really a reason to go down that track otherwise.
Yeah. And, I think of secondary effects here. I mean, just the name of it is like, well, that's exactly what happened in Reed, right? I mean, the concern wasn't the messages. It was, oh, well, there's going to be these traffic things when you have these signals and people are turning and all these sort of things that are downstream. And the court there was very clear. That's fine. You can talk about that, but you've got to talk about it in the strict scrutiny world. And that it just seems like, again, it's only because of the subject matter, like Brian points out, that we're treating this differently. And so it'd be interesting to see the Supreme Court wrestle with this. It's hard to see the votes there. They've got a very crowded docket, and it's just like, who's going to be like, oh yeah, this is where we need to stick our neck out and, kind of finesse our First Amendment jurors. Like, I don't see it.
They should grant it just to hear Justice Alito's questions, I suppose.
Hypothetically.
It didn't come up in the opinion, but it does seem a little bit, you could make the argument that the rent and theater case is a zombie precedent.
Yeah.
As was called the Lemon test for so many years, the old establishment of religion test. Seems like it still has a lot of life in the lower courts, and so I wouldn't exactly call it zombie precedent. But if the Supreme Court wanted to say it was, it could. But I'm guessing there aren't the votes there to actually declare it a zombie.
Yeah.
So that is what's going on in the 11th Circuit. Bring it back to Kentucky. So Evan, in prep for this show, sent me this old Hunter S. Thompson essay. I'm guessing you are a fan of his for the writing, a writing guy that you are. Anything you want to tell us
practice.
About? Yeah, about like the background of that. So the essay, we'll put a link in the show notes. Evan found a place online where it's posted. I think it's okay for us to link to it, but it's like details about how this is 1970, so how the Kentucky Derby actually happens, and it's basically this big everyone's vomiting. Essentially.
I can't speak from personal experience, but that sounds like what's happening. And this is, so you mentioned that this was the Derby episode, and this is kind of, we watch the race, of course, and do the Julius, but this is also a personal tradition, making time to read this essay every year, just to kind of set the stage. It's a nice, it's not super long, even as far as kind of vanity long forms go. It won't take you more than probably 30 minutes to get through. It's fun. It has a pace of its own. He's a master of pacing. The aside, it's for all the focus on his kind of lifestyle antics and everything else, the drugs are just kind of a means to an end to get to kind of the heart of the beast. And his writing is much better than just mere drugs. It's a matter of like catching details. It's a matter of presenting them in a way that kind of trying to phrase this is to not overwhelm you, but to also use the details to advance a sort of bigger point. And not
at times it kind of slips into like you're reading like James Joyce.
Yeah,
and
right.
All
So
these details just flowing with not a lot of narrative, and then he'll go kind of
pull you back,
step back, and then have kind of more of a narrative writing.
Right, and this is kind of the Gonzo ethos, right? Is to kind of focus, I think to rely more on the first person as a means of encapsulating what it's like to be in a place, to kind of butts up against like sociology or anthropology, where you don't, we have this image of the journalist as like this very respectable, I'm always focused on being the neutral viewer, which can often be kind of a cold vantage point to view something. And the Kentucky Derby deserves more than just a cold vantage point of, mere observation. It should be a participatory event. And I think he really captures that well. And so I always like reading it. It always makes me happy when the Derby's on and this is out. And, good Americana.
So, Brian, have you actually gone to the Derby?
I have. And I will say, a lot of people, you think of the Derby and you think of the grandstands and the hats and the mint juleps, and there's it's very highbrow, pretty dresses, seersucker suits, and Hunter S. Thompson. The infield is it's just a whole nother world of just chaos and debauchery. So the last time I was there, I was in the infield, and it was for when American Pharoah won the Derby on his way en route to the Triple Crown, and you're there for the party, and you just kind of see the horse fly by one corner briefly. So yeah, I think he hits the nail on the head.
Yeah, not the greatest vantage point in the infield, I would imagine.
Yeah,
you can do that on TV. At
this point in my life, I would go back. If any listeners have grandstand tickets and need someone to go help them bet, please reach out. But I will not be in the infield anytime soon.
All right. Well, you can find Brian's contact information on ij.org and click on staff. So he's standing by for your call. But in the meantime, I'd like to thank him for the preview and for his legal analysis, and same to Evan and for some legal writing citation tips and otherwise. And for everyone else, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all the other podcast platforms. And remember to get engaged.